bagenze on ground of establishing the only open.
Yes.
Please, Your Worship. Your Worship, today is 8th. Yes, Your Worship. Everything to the sign up for the state.
Your Worship, I'm holding brief for Council Babazi.
A3, Your Worship. Mpaji Sunday for A3.
I'm Sodo Brian, holding
Sodo.
Yes, that's level. Ego.
I thought Kamuta.
Press. Holding brief for Council Union Tono Asman for A2.
If you abuse it, then you caused the loss. That is simply what it means in these accounts. When the charges were read and explained to the accused persons, each one of them pleaded not guilty. A plea of not guilty was entered in respect of each accused, thereby setting in issue all the ingredients of the offences charged. Resultantly, prosecution had to prove each and every element in the offences charged in order to secure conviction against the accused persons, as required in the case of Secretary Co. A1 was represented by Land Council Mbabaz Mohammed, A2 by Land Council Nyenyintono Asman, A3 by Land Council Mpagi Ronald, Sunday. Principles and the law. In order to consider the culpability of accused persons, certain several principles of the law are considered. The accused persons are presumed innocent until the contrary is proved, as per Article 28, Sub-Article 3A of the Constitution of the Republic of Uganda, 1995, as amended. Therefore, the prosecution bears the burden to prove not only the fact that the offense was committed, but that it was committed by the accused persons, or that the accused persons participated in the commission of alleged offense. Regarding the standard of proof, the prosecution has the duty to prove all the ingredients of the offense beyond reasonable doubt. Refer to the case of Wilmington versus DPP 1935 SC at 462. However, this does not mean proof beyond shadow of doubt. If there is a strong doubt as to the guilt of the accused, it should be resolved in favor of the accused persons. Therefore, the accused person must not be convicted because they have put a weak defense, but rather that prosecution case strongly incriminates them and that there is no other reasonable hypothesis than the fact that accused persons committed the alleged crime. As to the standard of proof, is beyond reasonable doubt as discussed in the case of Miller versus Minister of Pensions, 1947, Volume 2, All England Law Reports, wherein Lord Denning stated as follows: that degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean proof beyond the shadow of a doubt. The law should prevail to protect the community if it admitted fanciful possibilities to reflect the course of justice. If the evidence is so strong against a man as to leave only a remote possibility of his favor, which can be dismissed with the sentence of course, it is doubt, but nothing short of that will suffice. And that duty does not shift to the accused except in a few statutory cases which is not this case, and the standard by which the prosecution must prove the guilt of accused is beyond reasonable doubt. With respect to the nature of evidence required, the accused persons can only be convicted on the basis of evidence adduced before court. Such evidence must be credible and not tainted by any lies or hearsay, and otherwise it will be rejected by the court for being false. I appreciate the zeal and the excellent level of headedness of each of them on the case and the statutory laws highlighted in the submissions. For the evidence presented, PW1 Odong James, the Assistant Commissioner Process Management in Domestic Tax Department, URA, told the court that his duties involve to design processes that are used by the clients to fulfill their tax obligations and to facilitate URA staff and other government agencies such as processes to do with the registration for tax, payment of tax dues like income tax, local exercise duty, non-tax revenues like stamp duty, passport fees, etc., based on the provisions in the Schedule 11 of the Stamp Act. As assessment or payment registration receipt, PRN, is generated for payment in the bank. The bank validates the receipt and receives the payment. The teller stamps on the receipt as evidence of payment, and after the client is expected to generate the stamp certificate. That stamp certificate is used as confirmation of payment. The certificate possesses the names of the person on the mortgage, amount paid, date, and purpose. The certificate is presented to Lands Ministry for processes of transfer. It is expected that the officers at the Ministry of Lands access the system by inputting to verify whether appropriate fees was paid for the specific piece of land, whereupon the client's documents are stamped and submitted for processing. It is submitted that the Minister of Lands have their system integrated with URA to register the value of the land, make assessments for stamp duty, and that specific officers have access rights. He identified some of the officers trained, and none of the accused was mentioned on the list he presented. Besides, that if a person is not trained, may not be able to perform the system in line of his or her duty. It was also his evidence that a barcode is provided on the PRN to enable track documents submitted to URA and its system generated, and that it cannot be shared and is specific for every document. He also pointed out in cross-examination that if a document has got several mortgages, stock plots, it's likely that we would share a barcode. He also told court that it's not the registrar who does the registration and assessing, but he reflects at the tail end of registration process. That's the duty of URA to collect stamp duty, and it takes it to the consolidated fund. That it's also the duty of the taxpayer to pay the stamp duty and not the employee. Regarding the failure to pay the tax, he told the court that if a person does not pay it, he can be prosecuted because the taxpayer is responsible for what he's supposed to do. Opio Robert. I think we meant Christian was swearing. In charge land registration told the court that he superintends over land registration in Uganda, and that all other registrars at zone offices handle land activities on his behalf. It was his evidence. Zone offices and receipt is issued upon deposit of the registration documents. They are received by the customer care officer, who does the verification of payment of stamp duty and registration fees. That the customer care has the leakage between URA, his stamps and sign off as verified on the document presented. That if customer care officer is ensuring that registration of all documents by the parties, government fees paid, that's a stamp duty and registration fee, among other things. That a registrar who goes ahead to register a rejected document would be considered negligent and could be subjected to disciplinary action. And that a person who executed the document would be liable for causing financial loss and is required to verify whether or not stamp duty was paid, but was the role of the customer care. He also identified A3 as a registrar who was under supervision by a senior registrar, but also attached to Guru Station. His role was of the registrar, and that in event he did not manage work well, he would be subject to disciplinary action. In his testimony in chief, he maintained that stamp duty was to be paid by a party who executed a document, and if it's a mortgage, it's the mortgagee who pays, and in this case, it was Centenary Rural Development Bank. According to the document, Centenary Rural Development Bank did not pay the stamp duty. And according to PID 1, there was proof of payment of registration fees of 25,000 and stamp duty of 22,909,740 for property under Block 22, plots 2986 and 2987 in respect of counts 1 and 2, although these fees do not tally with the screenshots extracted. Herein called associated mortgages / instruments. And he said that in such circumstances, registration is done against a single instrument by which money is paid, not a legal requirement to forward documents to registrar without receiving stamp. It was also his evidence that registration and stamp fees were paid in the rest of the counts as per the receipts presented and identified by him for all the counts against accused persons, and no financial loss was occasioned. And that it logically followed that there was no abuse of office. These are statements he made on record. He reiterated that this case was as a result of the raid of the Lands Office by Anti-Corruption Unit, and that there was no complainant. He maintained that he did not see any loss on the face of the record. Needless to say, he also stated that the registrar who could proceed on registration of the mortgage without proof of payment would be asked to explain. Also, that the EMZOs are not directly linked to URA, and that there are two versions of lease whereby the new system was linked directly to URA, unlike the old system, and that Wakiso was linked to the old system by then. He went on to identify the work of the registrar as provided in the Practice Direction 1 of 2018, herein marked Defense Exhibit 3, described their respective roles, including extra roles assigned to them. He also described the processes the documents go through and the roles staff play at every stage and registration on Land Information System as per Prosecution Exhibit 3 to Prosecution Exhibit 8. It was his testimony that the office was raided by State House Anti-Corruption Unit and some of the staff arrested. He recorded a statement herein marked Prosecution Exhibit 2, and he explained the operations of Wakiso Land Office. It was his testimony that URA was not connected to Wakiso EMZO, and that it was not the role of registrars to verify taxes, but A2 and registrars would verify documents. That registrars were not connected on internet, and that they rely on stamped documents by the customer care, as per Prosecution Exhibit 9, which was a communication which was to the effect that internet was to be disabled from all users except the customer care officer to verify URA payments and IT personnel. He also told court that it was the duty of the customer to pay taxes. He said that there was no audit issue raised for the loss of taxes and that he never said that any staff occasioned any loss. On his part, as regards training on verification of taxes, he said that he had never been trained and that in absence of training, they were not competent to verify taxes, that they did not have any officer trained in accounting, and that the issue of tax is technical. He confirmed in re-examination that he had limited knowledge in land transactions and that cannot verify payment of stamp duty, and that the duty of staff on tax is to only check for receipts for payments and not to physically pay for clients, and that they were to confirm attachments. As to FPW for Galiwango Haman Nsubuga, verified in respect of payments, which is done using the Revenue Portal website, and that A2 and Susan were the responsible officers. That internet was restricted at the reception, and that the process would continue with data entry and scanning and taking them to the registrar. That as a registrar, he could offer technical assistance to other registrars, and part of his other role was to do initial review, which entails ensuring signatures are on documents, payments of stamp duty and registration fees are paid with the receipts attached, and whether the document has received the stamp to comply with the registration process by the customer care. That once initial review is passed, the registrar signs the memorial and is rescanned. He also confirmed that the receiving officer would issue acknowledgement receipt, but that they were using a stamp not acknowledgement receipt as of land information system because it was what they found being used. Arrested them, computer and documents taken. He explained that they had challenges at work, such as late entry of work in the system because of heavy workload, lack of stationery to print acknowledgement, internet breakdown, inadequate computer, sharing of one computer by customer care officer, or congested reception. That was the mortgagee to pay the stamp duty. Also, that it was the duty of URA through banks and not Wakiso Lands Office to collect revenue. For PW5, Kumbuga William, working with Minister of Lands, Housing and Urban Development as IT officer and in charge of National Information Center, told this court that the land information system was developed to enhance land registration, physical planning, survey and mapping, evaluation, among others. And that the preliminary stages started in 2006 and developed between 2011 and 2012. And thereafter, in 2013, it was deployed in zonal offices of Wakiso, Mbarara, KCCA, Jinja, Mukono, Ministry Headquarters, and Masaka. That the system had different users who include the Registrar of Titles, Senior Management Officers, Surveyors, Land Officers, Customer Care Officers, Data Entry Clerks, Intake Clerks, Scanning Clerks, ICT Officers, among others. He testified that the rights are assigned based on the categories one belongs. He explained how a mortgage is registered. He stated that the customer care has to verify if the application is accompanied with the required documents such as a mortgage deed, proof of payment, which is the receipt from the bank, stamp certificate from the bank, payment for stamp duty, and registration fees. And that verification would entail checking through URA portal, which would return message based on the service paid for, such as stamp duty. That the EMZO customer care desk had internet for purposes of verification of payment. That the customer care officer would log in PRN, which is used to verify. That customer care officers were trained how to use the system. He identified A2, 4, 5, and 6 as officers he had ever interacted with and who had been trained on the land information system and deployed at Wakiso, EMZO. Is scanned in the system, verification of particulars, perusal whether there are payments, and verifies with what is on the system and that they were trained on the system. He also said that the system leave an audit trail. It was the provision of payments. It has the provision of payments. That payment is evidenced by payment receipts issued by the bank and stamp certificate issued by URA. He went on to present land information system application forms for all accused persons and duties as per Prosecution Exhibit 3, 4, 5, 6, 7, and 8, respectively. He told court that only customer care officer had internet for verification of taxes and other users had no internet as per the communication to the users presented as Prosecution Exhibit 9. Prosecution Exhibit 9, I repeat, was addressed to ICT administrators to disable internet access to all users to disable internet users to all, Prosecution Exhibit 9 was addressed to ICT administrators to disable internet access to all users save the customer care desk officer. It's dated 31st January 2019. In the cross-examination, he confirmed that the registrar does not verify payments from URA, but verifies whether stamp duty certificate and receipt from the bank are attached for that specific transaction. Also, that Prosecution Exhibit 9, which is email communication, was not copied to the accused persons, but to ICT and administrators. He also confirmed that Prosecution Exhibit 5, which is lease application form for A2, the customer care officer, did not have the rights of verification. Anglin Naruima Tenywa, PW6, the Assistant Commissioner, Human Rights, HR Management, Minister of Lands and Urban Development, basically presented employment records of accused persons and expounded on the role of each of them. These were admitted as Prosecution Exhibits 10 to 15. That is your employment record or letters. Each of the accused's title is as per the particulars of the charge sheet. She also told court in cross-examination that the roles and the duties are communicated in writing and that under normal circumstances, an employee is not supposed to deviate from the duties assigned to him or her. She told court that they did not know of any request from URA to train. Auditor, as per Prosecution Exhibit 16 and Prosecution Exhibit 17 in this matter, and authored a report admitted as Prosecution Exhibit 19. That they analyzed transactions on National Land Information System in the Ministry of Lands, and in particular viewed the National Land Information System and confirmed or dispelled diversion of funds concerning Land Information System, which was effected for Wakiso Lands Office. That they reviewed the system at Wakiso zone offices for particular counts. They identified the transactions related to leases, mortgages, transfers, and searches to ascertain the fees paid and collected by URA, established financial losses resulting from non-payment of stamp duty, and also established the individuals who handled each transaction resulting in financial losses. They obtained documents and reviewed them, interviewed staff, and also engaged URA. 10 transactions of interest were reviewed, which are in the particulars of the offences against accused persons. It was his testimony that after reviewing the systems, it was established that the mortgagors did not make declaration of mortgage to be registered at URA, and as a result, they were not assessed by URA. In regard to count 1, no evidence of stamp duty was found of 22,909,740 shillings under National Land Information System, but payment receipt of 25,000 from DTB for the mortgage registered on 17th of October 2018, and URA issued receipt for that payment, and that system showed payments were made by Bogie and others for purpose of preparation of the documents. That on record there was stamp certificate of payment of stamp duty, but when PRN was used to verify using URA portal, different results, stroke details were obtained. URA also confirmed in writing that the stamp certificate for transaction of Bogie as per their date was 15,000 shillings. According to Land Information System, the intake clerk for the mortgage WAC 00194-153 in respect of counts 1 and 2 was Manje Andrew Etu, scanned by Ayeru Mere, who is not charged. The data entry clerk and intake clerk was Manje Andrew. While initial review was done by Businje Nur. She lodged the application and registered as Great Lakes Regional Distributors Limited, and to Mwesige Herbert, stamp duty payable for mortgage of 3,325,000 was 16,625,000, which is 0.5%. It's his evidence that no evidence or proof of payment for stamp duty was found, but found receipt of 40,000, which was for different transaction. That physically the mortgage did, but using the same at URA, it did not reflect stamp duty of 16,625,000 fees paid by Great Lakes, but also the stamp certificate thereon. The user herein on list was Mwanje Andrew, and the initial review was by Businje Nur. In respect of instrument WAC 0019-1676, Miss AAT Technologies Uganda Limited, for consideration of 500 million shillings, the stamp duty payable being 2,500,000. That no evidence of stamp duty was found, but 2 receipts were found. The one of 4 million and 10,000 shillings, which was for A1. He told court, PW7 told court that he never looked and it was not authentic. Also that the stamp certificate was to be paid by the owner of the mortgage. That he did not also engage other MZOs to establish force to pursue. He said that was unable to confirm that A4 caused the financial loss and that she did not abuse her office based on the duties under Prosecution Exhibit. Confirmed that the old system of registration was not interlinked and that there was no URA staff to consult. Lastly, he confirmed that it was not the role of A5 and 6 to verify payment of stamp duty. The last defense witness was Detective Sergeant Mugerwa Charles. Unit was Prosecution Exhibit number 8. He told the court that the management of Kampala Metropolitan Police, KMP, headquarters received information from State House Anti-Corruption Unit about allegation of corruption, destroying records of land registration, non-payment and underpayment of stamp duty by the officials of Wakiso land offices. A team was set upon where he was among them and proceeded to Wakiso in December 2018 to commence investigations. A search was conducted in the offices, documents recovered, and some people arrested. Computers and phones were among the items recovered. On his part, he recorded statements from some of our accused. He also drafted a letter, which is Prosecution Exhibit 16, to the Auditor General to help to analyze the items and examine through audit the land information system. That the investigations were to establish whether payment or non-payment of stamp fees would be found on physical files handed to them. The 4 files in issue were admitted as Prosecution Exhibit 21A, B, C, and D, with the exhibit slip as Prosecution Exhibit 20. It was his testimony that the accused were charged based on the report from Auditor General that during investigations, he was able to access employment records of all accused persons and establish that they are all employees under the Ministry of Lands deployed at Wakiso Emzo. That the documents filed go through the Customer Care Support Stock Communication Officer. That receipt of documents was by use of stamp, yet the law provided by use of acknowledgement receipt. There was a computer at a reception. This is what he finds in his investigations. That there was a computer at a reception with intent for verification, with internet for verification of authenticity of payment receipts of stamp duty with a link connect to URA portal using PRN number to check the validity of payments, which was the duty of A2, to check and satisfy the appropriateness, suitability, and completeness, value of the mortgage attached, and that they were supposed to know the value of each mortgage. That they were supposed to know that all documents had gone through proper registration processes and stamped, and they were to refer back. The defense for all is that. The defense for all is that of denial of allegations against each of them. Accused in their respective defenses denied to have abused their office and to have caused their financial loss. A1 stated that she did what she was supposed to do by looking at the documents presented. The documents included a title which she had to ensure that it was not forged, the mortgage instrument, proof of payment of registration fees, and stamp duty. There To her, there was proof of registration and receipts and stamp certificate as proof of payment. And it was the basis she went ahead to pass the transaction in good faith, having passed the legal requirement as per the line of duty. That was the duty of the registrar, of the registered proprietor, to pay stamp duty and at any financial institution chosen by the registered proprietor. That she does not participate in the payment processes. As to associated mortgages, she dealt with plots in Wakiso after they had been dealt with in Mukono Emzo, and that stamp duty is paid once at the place of origin. She also looked at stamp certificate of 16,625,000 and registration receipt of 40,000 as per Prosecution Exhibit 19.6. Other payments she considered were as per Prosecution Exhibit 19 in brackets 7 for registration receipt of 20,000 and stamp duty of 4 million for block 263 plot 1674, which upon checking the payments were effected and there was no loss. She denied to have caused any financial loss. It was her evidence still that she was to look at proof of payment and the URA intake clerk to ensure information is entered and initial review is done by the registrar of titles. The intake clerk ensures that documents are entered and are valid and complete. She said that it was not her role to check the PRN, that the documents had barcodes, that Wakiso Emzo did not have barcode readers, and that A2 only looked at the affixed barcode on the instrument, nothing more. In his unsworn statement, D.W. Tumanje Andrew listed his roles as a customer care store communication officer as prescribed in Prosecution Exhibit 19 in brackets 16, that is the lease information system, and the verification of tax was not among them even at induction conducted on 14th to 15th December 2014 at the National Land Information Center as per Defense Exhibit 11. That he was assigned a computer and password, but did not have internet connection. That he had no knowledge in the verification of stamp duty or even on how to use URA portal. He denied to have been trained on it, save on land registration and management as per certificates presented as Defense Exhibit 12. That all transactions he worked on had proof of payment of stamp duty. They had barcode and stamp certificate, which are best proof of payment was for the internal use of URA. So to ask them to apply it, he's saying was not possible, and besides, it was the post of documents presented as Defense Exhibit 3.